Now, in the last half hour or so, you've been listening to Defence Advocate Barry Roux reiterating police disturbance of that initial crime scene. Now, Roux saying the state's version of what happened on that fateful night does not correlate with witness statements. Barry Roux, of course, will present his closing argument at the North Gauteng High Court tomorrow at 9:30. Now, we've been hearing from Defence Advocate Roux referring to parts of the testimony where Nell, that's the state prosecutor, accused Oscar Pistorius of lying on the stand. Roux also focusing on Hilton Botha. Now, you'll remember he was the investigating officer that initially took charge of the case. Roux also dismissing claims of a conspiracy regarding the positioning of the duvet and fan levelled by the state. Now, Roux is alleging that the position of the fan was indeed disturbed by police. He's also referring to photo 55, in which an extension cord is pictured here. Now, the length of that cord, the cord is in dispute. It was the actual cord that was plugged into the fan in question. Now, Roux is also poking holes in the testimony of Johan Stipp. You'll remember he was a neighbour of Oscar Pistorius, who heard calls for help. Now, according to Roux, those calls for help were heard by Johan Stipp at about 3:30 a.m. as gauged from Stipp's phone records. Now, also early in the day, we heard closing arguments by State Prosecutor Gerry Nel. Now, we heard that Nel relate the incident of Pistorius discharging his firearm through the sunroof of his sports car. Also, we heard how Pistorius handled a firearm in a public space such as Tasha's restaurant in the north of Johannesburg at Melrose Arch, with a child seated at the table close by. Now, the prosecutor, Gerry Nel, dubbed Bulldog by the media, has also said throughout the day that Oscar's defense is, I quote, devoid of truth. Nel also said Pistorius has told what he calls a snowball of lies that he simply can't get out of. You will remember that the state has tried very hard throughout the trial to paint Pistorius as a gun-toting, gun-loving, reckless personality, and now once again focusing on the evidence of ballistics expert, that's Chris Mangena, who said the firearm could not be discharged accidentally, but there had to have been a finger on the trigger. Well, we are drawing to the end of what has become one of the most sensational criminal trials in our country, and we'll bring you all the latest rolling live coverage right here on Channel 404. Now, our reporter, that's Patricia Visaki, is monitoring that developing story, and we are live to her now on the steps of the North Gauteng High Court. Good afternoon, Patricia, and thank you once again for your time on the PM News Desk.
Good afternoon.
Look, the final showdown between two of the nation's finest legal minds. Take us through the key points of Nell's closing argument today, Patricia.
Well, today the court heard how the state basically, went to the heart of their case against the Paralympian Oscar Pistorius. We heard Advocate Gerry Nel telling the court that Oscar Pistorius' version was appalling, that the Paralympian is a liar, and that he was deceitful when giving his testimony. But before I continue, let's just take a look at the Paralympian leaving the court. Just here behind me, you will see the stampede right in front of the North Gauteng High Court as he's making his way to his vehicle. Now, of course, you would understand that tomorrow he will be returning when his defense will be giving their closing arguments. But let's continue after, of course, seeing Oscar Pistorius leaving the court. As I was saying, that we heard Advocate Gerry Nel basically giving, a wrap-up of his case against the Paralympian, telling the court that there is no way that the Paralympian's version can be believed. It was filled with discrepancies. It is improbable and it should be rejected. He told the court that the Paralympian, tailored evidence when he was on the stand. He basically fabricated his whole account of events. And even when he had the opportunity to come up with a real version of what exactly happened on the morning of Valentine's Day when he decided to shoot and kill Riva Steenkamp, he rather became obsessed with finding an alternative version from what is called the truth. And right here, I have a document. This is a 107-page long document. This is the exact document that Advocate Kharinel today used, to present his closing arguments to Judge Thokozile Masipa and her two assessors, trying to seal the state's case against the Paralympian. And he basically closed his closing arguments today, telling the court that the Paralympian should be convicted on all accounts that he is facing in this trial. But to take us through some legal nitty-gritties right now, I am joined by legal expert, and this is Advocate Van Eck, who will now join me here. But basically, we heard that the Paralympian should be convicted on all charges.
That's correct. Well, he should finish with that, because at the end of the day, that is what he's here to prove. And then he obviously just says on all 4 counts as he was charged. So he has just indicated to us as a final way that they've not changed their charges at all. They've, for instance, not changed the murder charge to culpable homicide, but that he is sticking with the original charges.
And him basically highlighting repeatedly that the Paralympian disqualified himself as a credible witness on the stand.
Well, it's true. He said it is, well, it's true of what he said with regards to his version. He said in the beginning, well, you know what, he could have decided to not give any testimony in this case, and that is true. He could have kept quiet in this matter. And then, we would probably have the case where inferences had to be made from other people's testimony, and that can be a negative inference. But he had the choice to keep quiet, and I mean, it was a couple of stressful days for him when he was on the stand, and it was emotional days for him on the stand as well. And I believe that at the end of the day, he sort of tried to keep it together, but there was some discrepancies coming up, and there were some things that he wasn't sure about, and he was very tired later on, and he made some mistakes. And Kharinel wants to say, well, that's blatant lies, trying to fix your testimony as you go along. And yeah, well, he's doing his job. He should be trying to, give the judge that perception, and that he tries and convince her that that is exactly what's going on.
And him again, Advocate Kharinel, highlighting repeatedly the state's foundation, the foundation of the state's case, which is dolus eventualis. But going a step further, that not only should it be dolus eventualis, but right now the state believes that it should be dolus directus. What's the difference?
Well, at the end of the day, what they're saying is they've given him a charge of murder of killing Riva Steenkamp, so he had the intent to kill her. But what he's also saying is even though it cannot be that he hasn't proven beyond reasonable doubt that he wanted to kill Riva Steenkamp, he wanted to kill somebody, the person behind the door, because he at one stage said when he thought that the person was coming out and he wanted to shoot that person. So that is what he's getting to, the two differences. It's not only that he wanted to kill a certain person, but that he had foreseen that he was going to kill a person at the end of the day.
And this is where he actually supported that by saying the initial foundation of the defense's case was putative self-defense, but then the Paralympian changed it by himself when he was testifying, and therefore putative self-defense cannot stand anymore.
Yeah, well, at the beginning it was he believed there was an intruder, and he just wanted to sort of get rid of the intruder and scare him off. And then it changed to he shot automatically. So, without him thinking out of fear, he just gave off a couple of full shots. And then he said later on, well, you know what, I did really intend to shoot at the door or through the door because I believed that the person was going to come out. So that was his 3 versions. And it is difficult for a layperson to understand that what he's actually saying might change his what his defense. But at the end of the day, we have to go on what he's saying. We have to go, he's the only person there. And that is unfortunately what's now happened for him. He's changed his different offences.
Now, Advocate Gerrinel's main task was to prove two elements, and that was the element of unlawfulness and the element of intent. Did he do a great job in proving those two elements?
It would seem at the moment that it's 1-0 to Gerrinel, because he's now given his final arguments, and he's brought up the different aspects that he feels that the judge should look at. But I think we will only be able to give a final analysis of it as soon as we've heard what Barry Roux has said, and then what Gerrinel has answered on that. Because at the end of the day, he's only highlighted those points which he believes is important to his case. But we've not heard what Barry Roux has said. And Barry Roux has just started now, and he's just sort of touched on a couple of aspects that he says, well, this is a problem for the state's case. And it's going to be interesting what he's bringing up, what they have seen over the couple of past weeks, what was important to them to prove their version again. We must remember, Gerrinel must prove beyond reasonable doubt, and Barry Roux must just come and say, well, it's probable that our version is correct.
In closing, let's touch on some of the elements that Advocate Barry Roux now raised towards the end, basically going to the heart of one of their arguments throughout this trial, that there was tampering, with some key forensic evidence, and he pinpointed the police as being the culprits. And today, again, he tried to support that version.
Yes, he brought it up again. They did throughout the testimony with the different people coming up, and they said, well, you know what, there was the fans were moved, and the duvet was moved, and then the stuff in the bathroom was moved and stuff like that. And the only reason why I believe he's bringing it up now is because he's wanting to say, well, you know what, Gerrinel, you've said to us that the state's version is that what Oscar is saying can't be true, because the fan doesn't connect to it, or it wasn't in front of the thing, or something was not where he said it should be. But I'm saying to you, it can be true. It can still be true. His version can still be probable, because you guys went and you moved it. The state moved it. And I think that's why he's now really stressing that fact right at the beginning of his heads of argument.
All right. And of course, that being legal expert, Karen van Eck, just helping us to wrap the Oscar Pistorius murder trial as the state basically sealed their closing arguments right here at the North Gauteng High Court. And we will be back tomorrow, and of course, we're expecting Advocate Barry Roux from the defense to continue where he left off today, where he will try to prove to the court that Oscar Pistorius' version is probable, it should be believed, and that the state is wrong in asking the court to reject it in its entirety. We will be back tomorrow.